Apologies, everybody. I think I actually forgot to hit the start button. This has been recorded. If we have missed the start of the webinar, I do apologise. We have been having some technical issues today. Thank you, everybody, for joining us. And this whole thing has been recorded and will be available online. But Sarah has just started her presentation, so we haven't missed any content. Welcome.
Welcome, everybody. Just for those of you who might miss the start of my presentation is going to be broken up into two sections. First, I'll be dealing with the Mental Health Court, and secondly, with the Mental Health Review Tribunal. The law I'm dealing with today is subject to Queensland legislation, so I'm not looking at any law relating to the operation of mental health courts or tribunals outside Queensland. Now, effectively, I'm going to give you a bit of an overview about the tribunal and the court, because, of course, it's very difficult to support persons in those jurisdictions without that overview. I'll also talk to you about appeals, I'll talk to you about how legal aid can help, and I'll talk to you about other avenues for support. Now, I do appreciate we've got a mixture in the audience. I see we've got some social workers, support workers, and a fair chunk of lawyers. If there's not enough legal information in this presentation, I'm more than happy to take calls or emails from any lawyers out there who might require some further advice. So firstly, let's turn to the Mental Health Court. Now, the Mental Health Court decides the state of mind of people charged with serious criminal offences. The court decides essentially whether an offender was of unsound mind when they committed an offence, and whether they're fit for trial. The case of murder is a little bit special because the court also decides if the alleged offender was of diminished responsibility. Now, I should just say the Mental Health Court only deals with serious offences rather than simple offences, and I'll get into that definition in a minute. Now, in the Mental Health Court, it is formed by judges at the Supreme Court. At the moment, we have two judges. We have Judge Ryan and Judge Wilson. One of those judges is the president of the Mental Health Court. The Mental Health Court also comprises of some assisting psychiatrists, because let's be honest, lawyers aren't doctors, and the assisting psychiatrist advise the court on the meaning and significance of clinical evidence and issues relating to treatment and detention needs of people under the Mental Health Act. So there are often other experts in the Mental Health Court, psychiatrists, sometimes psychologists such as neuropsychologists, and there will also be other people with relevant qualifications or experience, as I said, neuropsychologists. And look, being a court, there are always lawyers. So there'll be lawyers representing the accused person, the Director of Public Prosecutions, the Chief Psychiatrist's Office, and sometimes even the Attorney General. Now, victims of crime aren't generally a party to proceedings. Actually, they're not a party to proceedings. However, victims or concerned persons can make written submissions to the court to assist the court with making a decision. So I did just say to you, I would touch upon what is a serious offence, because the Mental Health Court only deals with serious offences, or, there's always an or, associated offences. So offences that are associated with a serious offence. Now, I've got some definitions there for you on the screen. I guess the big thing I want to flag here is that there is a process for persons charged with simple offences in the magistrates court, where those persons might have been unsound or might be unfit for trial in the magistrates court. Now, I'm not going to touch upon the proceedings in the magistrates court and how the magistrates court deals with circumstances where persons are of unsound mind or unfit for trial, because that is a topic for its very own presentation. The Mental Health Court, as I said, considers serious offences or offences associated with serious offences. It's important to note the Mental Health Court doesn't consider Commonwealth offences. That's a biggie. So lots of terminology there. I apologise, I'm a lawyer, I love terminology, I love the law. So I guess one of the take homes that I'm recommending is that at the end of the day, courts and tribunals things get legalistic. If you are supporting somebody with mental illness or a cognitive impairment and they have been charged with a criminal offence, please get some legal advice. You can book an advice session with Legal Aid Queensland. So how do criminal cases get to the mental health court? Well, there's a number of avenues. Cases can be referred by the accused person or their lawyer on instructions, the Office of the Chief Psychiatrist, the Director of Public Prosecutions, a magistrate, or a judge of the District or Supreme Court. And there's different requirements depending on who is making the referral. Now, generally, referrals to the mental health court need to be accompanied by a report prepared by a psychiatrist. The report can be commissioned privately by a person or their lawyer, or it can be requested from the chief psychiatrist in certain circumstances, say for example where the person is already subject to involuntary treatment under the Mental Health Act, so they may be subject to a forensic order or a treatment authority, or even a treatment support order. And I imagine some of you out there are familiar with that terminology. So I guess when considering to get a report, there's some important things to realise. So if a report is commissioned privately by an accused person or their lawyers, that report can be funded privately, or if the person is legally aided, it can be funded by legal aid. Generally speaking, an independent psychiatrist selected by the person or their lawyer does the report, and the report is subject to lawyer-client confidentiality, and so it doesn't have to be presented to the court. In contrast, reports requested from the chief psychiatrist, look, they can be requested by the accused person, their lawyer, or their nominated support person, guardian, or their attorney, or their parent if they're minors. This report is prepared by a psychiatrist appointed by the chief psychiatrist, so not a psychiatrist of choice. And it's not necessarily subject to the same confidentiality requirements as, say, a privately commissioned report. So let's say you're legally aided and you might have a mental health condition, so you might have a mental illness or a cognitive impairment. What do you do? So Legal Aid actually has a specialist mental health unit that represents people in the mental health court, and we receive referrals from in-house lawyers and preferred suppliers doing legal aid work to assess merit for mental health court representation. And usually what we ask for is a legal aid application, because obviously legal representation by legal aid is subject to a means and merits test, which I'll expand upon a little bit later. So the mental health unit conducts a merit assessment, which will require the provision of information relating to the charges. That might be a brief of evidence, QP9s. Importantly, it will require provision of the psychiatrist's report, or if the person's got a cognitive impairment, perhaps it might be a report by a neuropsychologist. And then if the matter has merit and the applicant satisfies the means test, so they're of limited means, then the mental health unit will make a referral to the mental health court and provide representation in the mental health court. Now, in terms of stages with mental health court referrals, I like to warn everybody who's having a matter referred to the mental health court that the process is a long one, a bit like a marathon. So it can take anywhere from sort of 9 months to 2 years for matters to proceed through the mental health court. That's a really long time. And what I've done in this slide is I've sort of set out the processes or the steps that occur in between a matter getting referred to the mental health court and the matter actually being heard. So there's a lot of stuff that happens between the referral and the hearing date. So once a matter is referred, the referral document is reviewed by assisting psychiatrists. As I said, they assist the judges in the mental health court, make decisions, they give advice about the clinical relevance of information. And then a recommendation for a court-ordered examination may be made. So that, if it's made, involves examination by one or more court-appointed psychiatrists or psychologists to assess the accused person. The matter may then, once the reports are done, be mentioned in the mental health court and then listed for hearing. Now, I've done a really general diagram here, or flow chart of mental health court referrals at a glance. I haven't included cases involving murder because they require a consideration of diminished responsibility. But generally speaking, what happens is if somebody's charged with an indictable offence or a serious offence, or remember, an associated offence, and it appears that maybe they were of unsound mind at the time of their offence, or unfit for trial as a consequence of their mental condition, then they can be referred to the mental health court. The mental health court will then make a finding. I'm trying not to get too legalistic here, but one of the big things the mental health court will consider is whether or not there's a substantial dispute of fact. So the mental health court will make a bit of an inquiry into whether or not there is sufficient evidence to support the elements of the charges, and whether or not the accused person actually contests the charges. Now, if that contest is a consequence of the person's mental illness, then the court will decline to find a substantial dispute of fact. But I am going off into sort of a pretty legalistic area, so I'll just leave that at that. So the court will then have to decide whether or not a person was of unsound mind or unfit for trial. And if the court does find that a person is of unsound mind or unfit for trial, there are a number of options. Generally speaking, in cases where the court finds that someone's of unsound mind and permanently unfit for trial, the court will order either a forensic order, mental health category, a forensic order disability, or a treatment support order. Look, the court does have the option of making no order at all, but generally forensic orders are put in place in order to support the treatment of care of persons, and also to protect the community. So where serious criminal offences are committed, generally the court will place somebody on an order for their own treatment and care, but also for the protection of the community. So moving on to the next slide, when matters come to hearing, generally the hearings are of two types, either contested or not contested. It's pretty obvious. Contested hearings occur when parties disagree about the issues in dispute. And generally it requires oral evidence to be given by the reporting psychiatrists and psychologists. And typically these hearings can be really long. They can be half a day, or they can last for multiple days. If a hearing's not contested and the parties agree on the finding the mental health should make, it does reduce the need to hear oral evidence from reporting psychiatrists and psychologists, and it does reduce the length of the hearing. So it may result in a hearing only lasting an hour or so. Now, I provided you with a really straightforward flow chart before, because I acknowledge some of you are not lawyers, but of course, I think about 38% of you are lawyers. This chart, and I cannot take credit for it, it comes from the Mental Health Review Tribunal's website, provides a more detailed summary of the law, particularly the law in the Mental Health Act, about the findings that the mental health court can make. It also provides a little information about the down the bottom, about the relationship between the mental health court and the Mental Health Review Tribunal. And I'll talk about the tribunal later in the second half of this presentation. But essentially, once the mental health court makes an order, like a forensic order or a treatment support order, that order then is periodically reviewed by the Mental Health Review Tribunal, and decisions from or by the Mental Health Review Tribunal can then be reviewed, subject to the appeal process by the Mental Health Court. So I'm not going to delve into this in any great detail because I appreciate some of you are not lawyers, and I really just want to provide a general overview for those of you who are not familiar with the Mental Health Court or Mental Health Review Tribunal. But again, this is a very helpful flow chart, particularly for those of you who are lawyers. I take no credit for it. It comes completely from the Mental Health Review Tribunal website. So I just wanted to make some comments about mental health court hearings in general. They occur in the QE2 Courts of Law complex. It is a big court building. The hearings are generally more formal, so you'll find that you know, the lawyers and the judges will either wear suits or robes and wigs, very formal. The accused is generally represented by lawyers, and the accused addresses the court through their lawyers. So the accused generally doesn't speak to the mental health court justice hearing their matter. Now, generally, the accused person must appear in person or by video link. However, like most things in the law, there are exceptions. So if it's in the interest of justice and a hearing might proceed in someone's absence. So it may be the case that somebody is in hospital and too unwell to appear at their hearing, and so the court might proceed without them. As I said, there's a mental health court judge who presides. That judge is a justice of the Supreme Court. There are generally 2 assisting psychiatrists who sit up with the judge, and I've explained to you their role. And of course, there's lawyers, lots of lawyers. So generally, there'll be the accused lawyer, there'll be a lawyer for the chief psychiatrist, a lawyer for the director of public prosecutions, and sometimes there will be a lawyer for the attorney general there. Now, I think I've got a part there on that slide that says the decision is generally immediate or reserved. Usually after the court hears from all the lawyers, and as I said, the court doesn't really speak to the accused person, but after the court hears from all the lawyers and hears from any of the experts, if required, the court will take advice from the assisting psychiatrist and generally deliver an immediate decision, but sometimes it does reserve its decision if it needs a bit of time to think about what the appropriate decision is. Right. Look, I'm about to do a bit of a dive into legal terminology, but I think it's really, really important to understand concepts like unsoundness of mind, diminished responsibility, and fitness for trial, because these are matters that the mental health court has to decide and consider. So I want to first touch upon the concept of unsoundness of mind. Now, thankfully, this is defined in the criminal code, but if any of you are familiar with the criminal code, it's a bit of a wordy, confusing definition, but basically someone can be found of unsound mind if their mental condition deprived them of one of 3 capacities: the capacity to understand the nature of the act or omission, understand that they ought not do the act, or control their actions. Now, sometimes someone might be so unwell or have such a significant cognitive impairment that they actually might be deprived of all 3 capacities. But the reality is, for a finding of unsoundness of mind, there just needs to be one of those 3 matters there to be satisfied. And for the lawyers out there, unfortunately, the court is precluded from finding that someone's of unsound mind if there is a substantial dispute of fact. Now, as I said, if there is a finding of unsoundness of mind, that may result in the court making a forensic order or treatment support order. Now, diminished responsibility. This relates specifically to charges of murder. Again, it's defined in the criminal code, but basically, in a nutshell, it means that because of a mental condition, the defendant was substantially impaired of one of the 3 capacities there. So again, to understand the nature of act or omission, nature of the act or omission, to understand they ought not do the act or to control their actions. If somebody is found of diminished responsibility, this actually may result in the charge of murder effectively being replaced or substituted by a charge of manslaughter in the criminal court. So effectively, if you've been charged with murder and the charge gets referred to the mental health court and there's a finding of diminished responsibility, what can then happen is effectively the charge gets changed to manslaughter and booted back to the criminal courts to be finalised. It's a very simple explanation of something that is actually quite complex. Now, moving on to the next slide, unfit for trial. Now, unhelpfully or helpfully, I'm not really sure, this is not defined in the legislation. Case law defines unfitness for trial for us. Now, I did say I wasn't referring to legislation or law outside Queensland. I lied. The main test for unfitness actually comes from a Victorian case of the Queen and Presser. It sets out the criteria, which I've helpfully actually written down because I always repeat them in the wrong order, but it sets out the criteria for unfitness. So effectively, there are 6 criteria. If somebody fails to meet at least one of those criteria, they can be found unfit for trial. And I'll just canvass those in a minute. But what I want to say at the outset is that unfitness can be permanent or temporary. So as you can imagine, somebody who is, say, for example, suffering from a mental illness and it's been exacerbated and they're experiencing psychosis or mania, sometimes that can just be a temporary thing. And so after a period of treatment, that actually might resolve and they could then become fit. Of course, there are situations where fitness or unfitness can be permanent, and so that usually involves cases where someone's maybe got, for example, a treatment-resistant illness like treatment-resistant schizophrenia, or you know, they've got a really severe cognitive impairment. So just looking at the Presser criteria, I apologise for the lawyers out there because you're probably familiar with these, but the Presser criteria are effectively this. 1, the ability to understand the charge. So this involves the accused person having a basic understanding of the essential facts of the charge and the elements of the offence. 2, the ability to plead to the charge and to exercise the right of challenge. So the client basically has to understand what a plea of guilty means, so they accept the charge and the allegations, and they need to understand what a plea of guilty, not guilty means. 3, an understanding of the nature of the proceedings in a general sense, so namely that it's just an inquiry into whether or not they committed the offence, so a trial is an inquiry into whether or not somebody is guilty or innocent. 4, the ability to follow proceedings in court and to understand what's happening in court. Now that's just in a general sense. The accused is not expected to understand all the legal tests and legalese that's used. They just need to understand what's going on in a general sense. And, you know, the roles of all the parties in court. So 5 is the ability to understand the substantial effect of the evidence that might be given. So effectively, the accused person needs to understand the implication of evidence given by witnesses, and it might be that, you know, the evidence might be that it's likely that it's quite strong and it could lead to a conviction. And 6, finally, the ability to make a defence or answer the charge. So again, just in general terms, the accused has to be able to give the court a basic version of their events, either themselves or through their lawyer. And, you know, they need to understand that they could potentially have to get up in the witness box and give evidence and be cross-examined. Now, I should say there is another matter that does need to be considered, and it's it's not a factor in PRESA. Now, fitness for trial was defined in the old Mental Health Act to include the ability to endure a trial without serious adverse consequences to the accused person's mental condition. So that the definition of unfitness is no longer found in the legislation. It's actually now contained simply in case law, but it is a thing that needs to be considered. So the ability to endure a trial without serious adverse consequences to someone's mental health is a significant factor that gets considered. And look, at the end of the day, if the court finds someone's unfit for trial, whether that be permanent or temporary, the court can place somebody on a forensic order. They can also place somebody on a treatment support order. So moving on to the next slide, what happens if you disagree with a mental health court decision? It happens. So there is an avenue of appeal to the Queensland Court of Appeal. So if there's an error of law, you can appeal to the Queensland Court of Appeal. Time limits do apply, very important to remember that. People can be self-represented, they can seek legal representation too. It would be remiss of me not to recommend legal representation in the Queensland Court of Appeal. And of course, Legal Aid can fund representation in the Mental Health Court, in the Queensland Court of Appeal. It is means and merit tested. And look, there is a situation where if somebody is found of unsound mind by the Mental Health Court but is fit for trial, and they're not necessarily happy with that decision, they can elect within 28 days of the Mental Health Court decision to proceed to trial by filing a notice with the relevant courts and parties. So, you know, if you're found of unsound mind by the Mental Health Court, but you really want your day in court, there is this, this exception, which is an alternative effectively to appealing. Now, moving on to the next slide, appeals from the to the Mental Health Court from the Mental Health Review Tribunal. Now, the Mental Health Court will hear appeals from decisions of appeals of decisions made by the Mental Health Review Tribunal. As this slide says, you know, I recommend representation for such appeals, but of course, people can be self-represented. Some people might even say the self-represented litigant might even get a better result. The matter depends on the facts of each case. Again, if you do appeal a decision of the Mental Health Review Tribunal, Legal Aid can provide representation. It is again subject to a means and merits test, and decisions on appeals are final. So you probably said, Sarah, we've heard you talk about the means and merits test a few times. Can you explain what that means? Well, I will. Before Legal Aid will fund legal representation, there are two tests that are applied. There is a means test, so generally speaking, applicants need to be of limited means. So there's thresholds for income and assets because it is Legal Aid's objective to represent disadvantaged Queenslanders. And then secondly, the merits test. Look, that's a little bit more involved. There are three criteria or three tests within the merits test, because lawyers love tests. So firstly, there is a reasonable prospects of success test. That basically just means that if the matter does go on appeal, the applicant is more likely than not to be successful, and effectively the appeal is not frivolous or vexatious. There is a second test, the prudent self-funding litigant test. What a mouthful. You can understand why lawyers also like acronyms as well. Essentially, this just basically means whether or not a prudent self-funded litigant would risk their own financial resources to fund the proposed action, so the proposed appeal. And the third test is the appropriate spending of limited public legal grants for legal assistance tests, which basically means that it's appropriate to spend public funds on the appeal. So I guess the big thing to remember is that appeals from the tribunal to the mental health court are final. So this is probably a good time to start canvassing the Mental Health Review Tribunal. What is it? So the tribunal primarily reviews the involuntary status of people with mental illnesses and or intellectual disabilities, cognitive impairments. There is a link there to the Mental Health Review Tribunal website. It's a very, very good website. The tribunal's a statutory independent body, as I said, and it has set up this quite detailed website aimed at lawyers and persons appearing before the tribunal. So it's actually quite user-friendly. So moving on to the next slide, who is part of the tribunal? Well, the tribunal includes the president. So like the Mental Health Court, there is a president of the Mental Health Review Tribunal. There is a deputy president. There are lawyers, there are psychiatrists, and there are other people with relevant qualifications or experience. The tribunal is formed by a panel, and the panel always consists of a lawyer, often referred to as legal members, psychiatrists who are called medical members, and other members with relevant qualifications, and they're called community members. Now, the tribunal, like the Mental Health Court, acts or is created under the Mental Health Act 2016, which came into force in 2017. And the Act helpfully sets out some objects, and I've listed those there. So the object of the Act is obviously to improve the and maintain the health and well-being of people who have a mental illness or don't have capacity to consent to treatment, to enable people to be diverted from the criminal justice system, and of course to protect the community. And the objects are to be achieved in a way that should safeguard against the rights of a person, are least restrictive of the person's rights and liberties, and promote the recovery of the person's ability to live in the community without involuntary treatment. Now, moving on to the next slide. The Mental Health Act also contains a number of principles that must be considered by the tribunal when making decisions. The list of considerations or principles is quite long, so I'm not going to repeat them verbatim to you, but they include matters like recognising the human rights of a person with a mental condition, the role of support persons, and there are special considerations in there as well for Aboriginal or Torres Strait Islander persons and minors, because this Act captures or deals with both adults and minors. So under the Mental Health Act, the tribunal has the power to do a lot of things. So it conducts reviews of things such as treatment authorities, forensic orders, treatment support orders. It does fitness for trial reviews when the Mental Health Court finds someone only temporarily unfit. I'm not going to delve into the process for what happens in the tribunal with findings for temporary unfitness in any great detail, but if you're a lawyer out there and you want some further information, please do not hesitate to contact me. And I can talk you through the process because it can be a little bit confusing. The tribunal also conducts reviews of the detention of minors in high security units. The tribunal can hear applications, so for examination authorities, the approval of regulated treatment, such as ECT, an acronym for electroconvulsive therapy, and non-ablative neurosurgical procedures. You might say, what are non-ablative neurosurgical procedures, Sarah? Quite commonly, those sort of procedures, the ones that we see a lot of at the moment, are procedures where surgeons and psychiatrists are running clinical trials, are getting approval to put devices not too dissimilar from pacemakers into people's brains. It sounds all very full on, I know, but these electrical devices provide stimulation to control psychotic symptoms of conditions such as obsessive compulsive disorder, which can be very debilitating for people and can be quite treatment resistant. So the tribunal will also hear applications for transfers of patients in and out of Queensland. Now, finally, the tribunal will hear appeals against decisions by the chief psychiatrist or administrator of a mental health service. What sort of decisions, Sarah, you may ask? Well, that might be a decision to say, for example, transfer somebody, or a decision to exclude somebody from a mental health service. Now, I think, as I may have mentioned, hearings can be held periodically. So in the case of, say, for example, forensic orders and treatment support orders, they're periodically reviewed every 6 months. Hearings can also be held following an application. So people subject to involuntary orders can make an application at any time to have their order reviewed. Applications can be made by the person, the subject of the order themselves, the Attorney General, the Chief Psychiatrist or Director of Forensic Disability, you know, whoever is the relevant party or whoever's involved. And finally, tribunal hearings can be initiated by the tribunal themselves. So it might be the case that the tribunal says it is in a forensic order review, and for whatever reason they might think that it's appropriate to actually review the forensic order in 3 months as opposed to 6 months, so they can actually initiate an earlier review. Now, I guess it's sort of just breaking down this part of, or this second half of the presentation. I sort of wanted to break it down into 3 sections. So before the hearing, during the hearing, and after the hearing in the tribunal. So in terms of before the hearing, I just wanted to talk about approaching the jurisdiction generally, things like notices of the hearings, who can attend a hearing, self-reports, clinical reports, and other documentation and representation. I then wanted to talk briefly about what goes on during a hearing. And then I wanted to talk about what goes on after a hearing in terms of receiving decisions, asking for statements of reasons, appealing, and getting further advice or assistance. So I've just been given a time limit, a time warning, sorry, and we have about 15 minutes left. So I suppose in terms of approaching the jurisdiction, I just want everyone to keep in mind that the tribunal operates on an inquisitorial model rather than an adversarial model, and it's a therapeutic jurisdiction, and really where possible work should be conducted within the recovery framework. This places the person who is the subject of the proceedings at the centre of any decision making, and it's supported through collaboration with other stakeholders such as treating teams and support persons. So I think a big thing to realise about the jurisdiction is successful outcomes are individualised. And it's really important that those outcomes support the therapeutic alliance with the person's healthcare professionals and don't damage the relationship. Because I think the thing that anyone who practices in the tribunal realises is that better outcomes are achieved through a collaborative approach rather than an adversarial approach. Now, again, in approaching the jurisdiction, it's really important to realise that people who come before the tribunal come from diverse backgrounds with varying degrees of disability. and we need to be mindful of those matters to ensure that everyone that's involved or the subject of proceedings is given the best opportunity to participate. Really, I think if you are a legal representative in the jurisdiction, you really need to do everything you can to enhance somebody's capacity to participate. Yes, legal representatives, you play an important role, but also guardians and support persons do too. So there's a couple of slides now on receiving notices of the hearing. So, you know, you can anticipate when a hearing is going to occur if it's periodic. And look, the notice will generally advise the nature of the hearing, when and where the hearing will be held, and it will detail some information regarding the rights of the person subject to the hearing. And who receives a copy of the hearing notice will depend on the type of hearing. Now, there is a poll there, but I might just skip it because we are a bit limited for time. But in short, the answer is all of the above. Oops, I've just skipped a page. Now, as I said, who gets a copy of the notice of hearing will depend on the type of application and who is involved. Now, notices can be given to guardians or attorneys, so it's important if you are supporting somebody before the tribunal and you are a guardian or attorney that you inform the tribunal of your appointment so that they can ensure you also get a notice of the hearing. Again, another poll. I'm going to give you the answer. Now, Nathan can attend. He can attend as a support person. So who can attend a hearing? There are a variety of people who can attend. Now, I think the big thing to realise with tribunal hearings is they're not open to the public. This is in contrast to mental health court hearings, and I should say I neglected to mention this earlier, but generally mental health court hearings are open to the public unless the court makes an order to the contrary. So if the court thinks it's not in the interest of justice, the court can close mental health court proceedings. The court will also close proceedings in the mental health court where proceedings relate to a minor or where the matter being heard is actually an appeal of a decision from the tribunal. So there's a list there of people who can attend. It really just speaks for itself, and it really does depend on who, it really does depend on the type of matter being heard. But I think it's really important to understand that patients or persons appearing before a tribunal can be supported by at least one support person or two support people with the permission of the tribunal. It's not too dissimilar for the mental health court. So the tribunal can conduct proceedings in the absence of involuntary patient. The test is a little bit different from the mental health court. Effectively, the patient needs to be aware of the hearing and has chosen not to attend, or the patient's too unwell to appear, and it's appropriate and expedient to do so or proceed with the matter in their absence. I should say the persons who are the subject of examination authorities don't attend their hearings because it effectively gives them notice that they might be subject to an examination authority. Again, that's probably something that I could probably discuss ad nauseum, but I won't. Now, one thing I really want to drive home if you are supporting a person before the tribunal, particularly if that person doesn't want to attend, is to complete a self-report. There is a blank form attached to notices, and it's effectively a questionnaire that can be used for a person to provide information about themselves and their progress to the tribunal. Really, really, really helpful, particularly if somebody, even if somebody is going to attend, it's a really good way to help people in the tribunal articulate themselves, because we all know nerves can get in the way of articulating someone's self quite well. I've got a slide here about clinical reports. They're something that have to be provided for certain matters such as forensic order reviews and treatment support order reviews and treatment authority reviews. There are rules about the timing for when they must be provided. It's very important that people get them with adequate notice to ensure, procedural fairness. Now, other documents might be provided as well to the tribunal. Again, reasonable time does need to be given to parties to consider those documents, and generally the tribunal requires these documents 3 clear days before a hearing. Victim impact statements are something that are not provided to the subject of tribunal hearings unless permission has been given to do so. There is a specific section of the Mental Health Act that deals with that. The tribunal may even order that an impact statement is not provided even where permission has been given by the victim or the victim's family. Now, moving on to representation. I guess this is a really important slide, and I know we're short on time, but the Mental Health Act does specify that people who are the subject of proceedings may be represented by a nominated support person, a lawyer, or another person. And it's really important that where somebody represents a person at a tribunal hearing, they must express the person's or represent the person's views, wishes, and preferences, or to the extent that they can't be expressed, represent the person's best interests. Really, really fundamental rules for representing somebody in the tribunal. Now, there are some fact sheets available for representing people in the tribunal if you're a nominated support person. Links are there, very helpful guides. And for the lawyers out there, the Mental Health Review Tribunal does have the discretion to appoint legal representatives for certain matters, and I've listed a number of matters there that the tribunal must appoint legal representatives for tribunal matters. And if you are a preferred supplier who has done the requisite training, then you might already appear on some matters before the tribunal. So where a lawyer is appointed by the tribunal, that's at no cost to the person. So if you're a support person and you're supporting someone who finds out they've had a lawyer appointed to them and they're worried about legal costs, it's at no cost to the person. So there is a process for the appointment of lawyers. The tribunal will contact Legal Aid, and then a lawyer will be nominated with the assistance of Legal Aid. It may be a Legal Aid or lawyer, it may be a preferred supplier. Important thing is lawyers appointed by the tribunal are independent of Queensland Health and the tribunal, and lawyers appointed will contact clients or people appearing before the tribunal before their hearing to speak with them and obtain their instructions with respect to their views, wishes, and preferences where possible. Again, lawyers appointed by the tribunal need permission or consent to speak to other people. So that's very important. Now, if a person has been notified of their hearing date and think they should have been appointed a lawyer but haven't heard from their lawyer, they can contact the tribunal on that number below. So there are specific rules about disclosure of personal information by a health service. Given the time constraints, look, that slide speaks for itself. Now, just in terms of legal representation, there are standards and guidelines that need to be followed. Lawyers representing persons in the tribunal, or lawyers, sorry, appointed to represent persons in the tribunal must be accredited by Legal Aid Queensland. And Legal Aid Queensland has case management standards and best practice guidelines that are available on a website that the lawyers must follow. Again, a poll. Mary's 51. Oh, what is the answer to this? yeah, Mary can choose not to be represented by the tribunal appointed lawyer. So if you don't want the lawyer appointed for you, you are at liberty to refuse them. Now this slide is a little bit wrong in the sense that it does say this can be done by sending some written correspondence to the tribunal at either that postal address or the email address. Oh, actually, no, it was corrected. A person can also tell the tribunal at their hearing that they don't want the appointed lawyer. The qualification being that that person must be an adult and they must have capacity to make that decision. So that means that minors can't waive the appointed lawyer. So independent patient rights advisor can assist patients who don't want the appointed lawyer. And I should say the IPRAs are just a wonderful, wonderful source of information and advice. And I've provided a link to the fact sheet there. And I really wish I had more time to discuss all the wonderful things that the IPRAs do because they are independent and their role is to advise patients and support persons, families, carers about rights under the Mental Health Act. There's some slides now on the conduct of hearings and we have about 5 minutes left, but what I would like to say is these hearings in general are a lot more relaxed than the hearings conducted in the mental health court. Whilst the slides largely speak for themselves, the tribunal really does like having the person subject of the proceeding present because they really do like to speak to the person present. It's a bit different from the mental health court because they just speak to your lawyer, but in the tribunal likes to make inquiries with the person subject to the proceedings directly. And again, it's not as formal as mental health court proceedings. It's much more relaxed. There's some notes there about the conduct of hearings in general. And effectively, each panel conducts hearings in the way it sees fit. There are some basic rules they have to apply, and they must act fairly in accordance with the merits of the case. So the slide largely speaks for itself there. And again, this slide sets out effectively what happens generally in a hearing. And again, this flowchart really speaks for itself. Now, from the 15th of November, the tribunal began recording hearings electronically. It used to just take written recordings, but now the tribunal is electronically recording hearings. And look, there are some great information sheets and policy sheets designed for lawyers and persons the subjects of proceedings on the Mental Health Review Tribunal website. Persons can request recordings. They may request transcripts, but transcripts may not necessarily be provided, but they can definitely get their hands on recordings. But look, I think if you're really wondering about why the tribunal has made a certain decision, it is best to request a statement of reasons because that sets out the reasons behind a tribunal's decision. Now, look, the tribunal will, I should say, decline electronically recording hearings if there's compelling reasons to do so. So for you lawyers out there who are representing people in the tribunal or support persons representing people in the tribunal, then just turn your mind to whether or not there might be a compelling reason for not recording a hearing. I don't think that the tribunal has made any decisions yet not to record hearings because this is all new. But if you want any information or advice about the recording of hearings, please do not hesitate to contact me or one of my colleagues at Legal Aid Queensland, and can provide you with some more information about the recording of hearings. I've got some information there about after the hearing, what happens. The notice of decision comes out. As I said, a statement of reasons can be requested within 21 days of the decision if you're curious about why the tribunal made the decision it made and if you're considering an appeal. As I said, there are appeal options. An appeal can be lodged to the Mental Health Court within 60 days of a decision. And look, if you're unhappy or you want some information, or potentially you require some representation in the Mental Health Review Tribunal, please contact Legal Aid. The same goes for those who want some information, advice or representation in relation to mental health court proceedings. If Legal Aid isn't able to assist, there are other avenues or other referrals we can make to community legal centres or private firms. We really do like to ensure that everybody gets the help that they need. And sometimes if we're not capable of providing that, we can certainly provide a referral that will hopefully be of assistance. Now, I'd love to answer some questions, but I think we've run out of time. If you do have any questions, please feel free to email them through to myself, and I will answer them, do my very best to answer them to the best of my ability. Thank you, everybody, for attending today.
Thank you so much, Sarah. That was a really engaging presentation. I just wanted to thank as well our Auslan interpreters who have been helping us out today, and our live captioner. And apologise that our captions weren't available on the screen today. We did again have some technical difficulties, but they will be available on the live recording. Thank you so much, everybody, for joining us today, and thank you, Sarah, for hitting that bang on 12 o'clock.
Everyone can get lunch.
Thanks so much. That's our last webinar for 2023. If you do have any questions, or if you wanted to find out what's happening in the webinar space next year, you can jump onto our website. On the screen at the moment are our phone numbers for Legal Aid. If you have any questions at all, you can jump through on one of those phone lines. And there is our website with all of our publications and resources. A lot of those are available to order if they're not available online for free. Just send us through an email. I'm just wondering if that's going to go any further. No, it's not. Okay, technical difficulties have plagued us today, but anyway, thank you so much, everybody, and we'll see you next year.